understand your topic, and then you are absolutely welcome to come and chat. I'll make it quick so that we get there quick. I don't take up most of this time. Today's not about me. So John is a senior lecturer here at the School of Law, and he teaches tax law and administrative law. And prior to joining Western, he practiced as a barrister, and prior to that, he worked in Amsterdam as a senior research associate with the International Bureau of Fiscal Documentation. He completed his Doctor of Juridical Studies at the University of Sydney, where he taught and has taught international tax at UNSW as well. He writes on matters of taxation, publishing extensively in leading specialist and generalist law journals. Today, John's discussion is going to focus in on a recent case on that dealt with the external affairs power under the Constitution, G Global, which is a 2025 decision. And John is going to be considering whether Section 5129, the external affairs power, is capable of authorising a law that allows Australia to unilaterally repeal its international obligations. And in particular, in considering this question, John is going to be discussing the intersection between Pacta, Sunt, Servanda, and treaty and the constitutional framework for treaty implementation. So without further ado, and sharing John's slides, I invite him to come join us.
Thank you. Will you be able to when I say just next slide?
No, because you can.
Oh,
Actually, no, I can do that. Yes.
Connected.
Yeah, that's fine.
First slide, yeah.
Yes.
Start with that.
Sure. Thank you, everyone. John.
Thank you.
Thank you.
Look, this is a talk that will span over an hour, I suspect. I'm going to have to abridge it somewhat. There are 11 slides, and I thought if I spend 5 minutes per slide, that's 55 minutes. I'm already over time, so I'm going to have to abridge it. But let me just start by saying, acknowledging country and that we are appearing on unceded lands. But I'm here to talk about international law. And I'm here to talk about constitutional and international law, and a particular topic, G Global, a decision of 7 judges of the High Court on the scope of the external affairs power, Section 5129. To start with, the title of my talk is Pacta, Sunt, Servanda and Treaty Override. So I need to explain what that is. Pacta, Sunt, Servanda is an ancient principle of customary international law. And customary international law is that which encapsulates consistent state practice and that which states feel legally obliged to follow. And it's encapsulated, the concept of Pacta Sunt Servanda is encapsulated in Article 26 of the Vienna Convention on Law of Treaties. The Vienna Convention on Law of Treaties entrenches or codifies customary international law pertaining to the application and interpretation of treaties. And in particular, Articles 31 to 33 of the VCLT, the Vienna Convention, are considered appropriate worldwide. They've got worldwide recognition of governing or regulating the interpretation of treaties. Now, under the Pacta Sunt Servanda rule, the whole state is obliged to follow, is obliged to perform the treaty in good faith. Now that is, it's an airy-fairy concept to understand, but it is a rule of conduct that states acknowledge. And one of the acknowledgements of that is that when you are entering into a treaty, you undertake, it's an implied obligation, implied duty that you undertake to observe or perform or discharge your duties under that treaty, the obligations that arise under the treaty in good faith. So one example is if you are going unilateral repeal or unilateral derogation from the treaty is an obvious example of bad faith, not good faith. So what we call, which leads me to the next slide. Treaty overrides. Yep, that's not coming up. What's that? close. What is a treaty override? Well, if you're American, you know all about it. In Australia, we try not to do treaty overrides. And it's a legislative change that one state brings to override its obligations under a treaty unilaterally. And it's to be distinguished from the state changing the definition of a term that's used in the treaty that's also appears in domestic law. Now, if the treaty does not define the term, and then the domestic law definition seems to be in contrast or inconsistent with the treaty term, that's okay. It's not treaty override. It's also been distinguished from amendment of a treaty under international law. Amendment of a treaty is where it's by consent. It's a political issue. The parties get together, the contracting parties get together and decide to amend the treaty which is no longer fit for purpose. Which is opposite to when a country on its own decides that a treaty is no longer fit for purpose and decides to change the law itself without consulting. It's also different to modification of a treaty. Now, parties, contracting parties can get together. There can be a split group that decide, look, we want to modify the application of this treaty. But amongst it, again, there's consent, there's consultation, there's negotiations, there's agreement, there's consensus. Unlike override, which is a unilateral move that we will go our way. Now, Americans are notorious for doing this. They're frequent overriders. They do this in particular, especially in tax treaties. They feel that they've got the model convention that they want to subscribe to, and so they're very particular about that. Also, termination for material breach. Now, treaties can be terminated for material breach, and what constitutes a material breach is obviously a subjective matter that depends on what the innocent party has done or has not done. If it feels that it's been an egregious breach, that it's been denied the benefits of the treaty, then it could terminate for material breach. But then that is all required. What's required is an objective assessment of the treaty benefits and whether they're actually fulfilled under the treaty to allow for termination. So that's, again, treaty override is not that. It's not saying that the treaty is terminated, it's just saying that the treaty is modified in one particular way, unilaterally. It's also to be distinguished from reservations. Countries, when they enter into treaties, in particular in tax treaties, they can express their attitude towards a particular provision of a treaty by saying, look, we expressly reserve the right not to apply this particular provision in this particular instance. So and that's anticipated, that's realised, which is, again, unlike unilateral override, which is completely ignoring or contravening or derogating from a treaty, what we call a repugnancy. It's a repugnant law that doesn't exist in the that's not anticipated in the treaty. And the treaty itself provides mechanisms to modify, terminate, or amend the treaty. But so if you're not following any of those steps, then you are doing what we call a treaty override. As I say, the unilateral modification is a serious threat to international relations that can damage the reputation and hence the national interests of the offending state. There's research that says that America is, when it negotiates tax treaties with other countries, because it has a history of overriding, then the favourable treatment that it tries to garner when it negotiates a treaty, because at the end of the day, a treaty, why do countries enter into treaties? Is to advance their national interest in a globalised world. And in the case of tax treaties, they're imperative for helping stem or protect the revenue base in relation to cross-border transactions, activities, trade and investment, especially in the globalised, digitalised world, where you need the cooperation of the other state and what treaties end up doing is they provide a unified, consistent basis for dispute resolution. So treaties are very, very functional, very useful, and they've helped assist Australia's historically we've got about 45 treaties in terms of tax, 45 treaties. And why I'm focusing on tax in particular, tax treaties, is because that was the subject of under consideration in the G Global decision. Now, tax treaties are treaties. There's no different. They're international treaties. It's an international agreement that modifies, that qualifies the states, the way states operate in relation to the treaty. And so it is a qualification on sovereignty in that sense. You know, we concede and exceed our sovereignty to realise, and what happens with treaties, tax treaties in particular, is they're given domestic effect, and they prevail over inconsistent domestic laws to that point. So that facilitates and it shows to the world that we are serious about our treaty obligations. Next slide. So we've got Pacta that says you've got to perform a treaty in good faith. We've got treaty override that says that's not good faith. And then we've got the Constitution that says a country like Australia, it's a sovereignty of Parliament, means that they can make and unmake any law they wish. If they make a law, they can unmake it. And in particular with treaties, Australia makes a law that enforces a treaty, that says, gives effect to a treaty. So it's by domestic law. Section 5.1 of the International Tax Agreements Act says that the tax treaty that Australia has concluded, that the executive has ratified, negotiated and ratified, will be implemented. Until such time, that treaty has no force, no legal force, no domestic force in Australia. So that it's a domestic legislation, it's a domestic matter, yes, agreed. However, but for any law to be valid, it has to subscribe to one of the great heads of power in the Constitution. And a law regarding that allows Parliament to implement a treaty is the power is the External Affairs power, section 51.29. Now, as I say in the third point, that the Australian legal system, like the UK, generally subscribes to the doctrine of separation of judicial power from other arms of government. And it's unlike the American system where the executive is clearly defined and members of cabinet, members of the executive are not also members of Parliament, Congress. In Australia, cabinet is comprised of ministers who appear in Parliament, so there's a blurred distinction. So that's why we say we subscribe to the Australian, to the UK system, more like. But as I said, absent some constitutional limitation, the Parliament has power to implement a treaty. And it has power to unimplement that treaty. But that power to unimplement that treaty has to be given validity, has to have some grant of head of power that authorizes it, that supports that unimplementing law. And so, as I say in the last point, absent some constitution, a law that repeals a valid law is usually supported by the head of power of the law repealed. So, if there is a law that unimplements a treaty, the law that implemented the treaty would have had power support from section 51.29. So the unimplementing or inconsistent law has to also find validity in section 51.29, which seems to be a paradox. We think, well, how can a law that supports a treaty, implementation of a treaty, also support an unimplementing law or disimplementing law? Well, we'll see in a minute. When we come to the International Labour Organization case. But before that, what is international law? Well, there are a number of sources of international law. The two principal sources are customary international law and treaties. And in a dualist system like Australia, we only recognise treaties when they're incorporated, as I said. But in most countries like America and civil law and European civil law jurisdiction, European countries, more or less a ratified treaty is effectively self-executing. Except in America, it's only self-executing to the extent that it has non-political deals with non-political matters, issues. But we don't have self-executing treaties here. They have to be implemented by Parliament, but irrespectively. But unincorporated norms that come from customary international law may nevertheless be taken into account, and they indeed inform and shape the development of common law in Australia. And Justice Brennan in Marbo's case famously resorted to an ICJ opinion on the Western Sahara to deal with terra nullius, the concept of terra nullius, doctrine of terra nullius, and what that is. And it said that if there are tribes existing, you can't possibly say it's terra nullius unless you can show that there's been agreement between the tribe and the colonizers that you've taken over sovereignty. And so Justice Brennan, as he then was in Marbo, used that very, very much to say, well, the doctrine of terra nullius that the Commonwealth is relying on to say that there is no such thing as Aboriginal rights is wrong. They existed. So international law has served Australia's purpose. And as I said, treaties serve our national interests, our economic welfare and well-being. So we've used international law, except the drafters of the Constitution looked at international law as some sort of aberration, something that could be ignored at will. And so there's no mention of international law in the Constitution. Nevertheless, there was, during the constitutional debates, talk about treaty power, and they were going to specifically include treaty power, but it was considered back then that Australia was still a colony. The treaty power was deferred to the UK Parliament, to the British Parliament rather than the Australian Parliament, so they took it out of the Constitution and just dealt with external affairs. However, international law can't be just ignored at will. A long-standing common law doctrine that is widely accepted throughout the Western sphere is that international law it's based on international law, doctrine of international, customary international law, and comity of nations, that as far as the language of a statute permits, it should be applied and interpreted consistently with international law norms. Now that is acknowledgement that international law, it does exist, and the rationale for that, as Justice McHugh said, is that Parliament is taken not to have intended to legislate in violation of the rules of international law existing when the legislation was enacted. So it's an acknowledgement, yes, that if that's saying treaty override is in violation of international law. International law says you must act and perform your obligations in good faith, and not doing so by not consulting, that's not acting in good faith. So that's one aspect of international law. The other aspect of international law is what does the treaty, the scope of the treaty, you need to interpret the treaty. So applying the treaty is one aspect of it, that's Pacta. The other aspect of it is interpreting or construing the treaty obligations which the domestic law is seeking to implement. You need to understand, what are you implementing? It's not just a domestic act saying, oh, we give full effect, because in tax treaties what the domestic law does do is give full effect to every provision of the treaty as if it's domestic law. Unlike other treaties, other conventions where the domestic law merely transposes words or terms that are appearing in the convention, in taxation treaties, they are transposed in full treaty. And so to show contrary intention, that Parliament did not intend for the law to be construed consistently with international law, more than mere general words and required. Now, Justice Williams in the Politis case, which is the landmark decision on international law, said that general words will be in statute will be read down to accommodate this principle of consistency, presumption of consistency as it's called. Okay, so that's international law. And then going back to the next slide, going back to section 5129, when will a domestic law be with respect to external affairs? Because that's the head of power that deals with treaties. We all accept that. Well, the majority with whom Justice Dawson concurred in the International Labour Organization case, or the Industrial Relations case, Act case, that case was dealing with recommendations and conventions coming out of the International Labour Organization dealing with parental leave, minimum wages, right to strike, a number of heads of matters that were dealt with, and there was a Law Industrial Relations Act that was trying to give effect to those various standards and recommendations. Now, they weren't implemented treaties per se, they were just trying to transpose the ideas from them. And they weren't doing it all in full. And so the question then became, can you still claim a law that seeks to engage Section 5129 but only partial implementation of the treaty? And the majority said yes, you can do that. It doesn't, the 5129 does not mandate that you must give full effect to the treaty. Partial implementation is fine. And as I say there, it's not essential that the law implement all obligations under the treaty. However, Section 5129 is not enlivened if the deficiency is so substantial as to deny the law the character of a measure implementing the convention, or when coupled with other provisions of the law, make it substantially inconsistent with the convention. So the substantially inconsistent criteria. So it says if it's inconsistent, it's fine. So long as it's not substantially inconsistent with the treaty, then it's fine. Remember, you need a head of power to make a domestic law valid. And a head of power that, if you're trying to bring a law that override a law that engaged 5129, then that law, that unilateral inconsistent law, must necessarily engage 5129 and must not be substantially inconsistent with the treaty. Although 5129 there says nothing about the treaty. So that, to my mind, says, well, okay, so we're dealing with the treaty. When is a law substantially inconsistent with a treaty? At what point does it become substantially inconsistent? Now, the judges in the ILO case, the International Labour Organization case, did not talk about it. They sort of faffed about around the idea, and I looked at one example, right to strike. It's 163 pages. Now, I wasn't going to read it all, but you can only discern all the fundamental principles from it in terms of 5129, because it's not only just 5129 case. And they looked at right to strike and said, look, okay, the Commonwealth doesn't implement the right to strike that under the ILO recommendations and convention, okay? But what it says is that if you're striking, then you are immune from common law action. And they said, well, but that's only partial implementation, but noting that also that the right to strike is also in state awards and legislation. So that's okay. There's been partial implementation, because although the Commonwealth hasn't done that, states pick up the slack, the gap. So that's okay, it seems, but they didn't say it specifically like that. Anyway, so there has never been a definitive answer to this until we get to G Global. And we're going to come to G Global in a minute. But what's more interesting too is that 5129, the jurisprudence on 5129, it says that 5129 will be enlivened if only if an obligation, it doesn't give rise to a positive obligation, so long as it's an ancillary to that positive obligation. So it's an international duty, yes, but it can also encompass ancillary, reasonably ancillary duties to matters that help that in discharge or fulfill discharge of that obligation. The case is Richardson Forestry Commission. I thought very interesting case. In that case was the Lemmantine Southern Forests in Tasmania and the World Heritage the Section 16 of the Levantine Southern Forest Act that sought to set up an inquiry to work out if the Levantine and Southern Forests in Tasmania have World Heritage value. And the Heritage Convention basically prescribed that governments must set up inquiries or allocate areas of forest which are World Heritage and then protect those forests. So Section 16 did that. So the court said, yes, that's fine, that's a positive obligation under the convention that Australia is giving effect to, so Section 16 has validity. But Section 16 went on further and said that while this inquiry is in play, no, you can't log. There is no logging to be going on. So they banned any activity in that forest before it was deemed World Heritage. And they said, well, that's not an obligation that's arising under the convention per se, but the majority, Justice Mason, I think, and with Wilson, or no, Mason and Brennan, basically said, that's fine. It's ancillary, it's reasonably needed, this inquiry, and they can do that. So it has that law, Section 16.1, that part of Section 16.1 is valid because it engages and enlivens Section 51.29, albeit that doesn't give rise to a particular obligation under a treaty, or doesn't relate to a particular obligation under a treaty. Now also, but the one condition or the one limitation on 51.29 is that it can't be enlivened to give obligations of aspirational obligations. The example I give here is where there is no real consensus what the contracting states are expected to do. It says the law must prescribe a regime that the treaty has itself defined with sufficient specificity to direct the general course to be taken by the signatory states. But the point at which ideals merge into legal obligations constitute one of the most delicate and difficult problems of law, and especially so in the international arena where aroused expectations are more difficult to ascertain and apply than in domestic jurisdiction. So if a treaty says, if a law says we want to give effect to this treaty that seeks to promote full employment and doesn't provide what a government is supposed to do, what a state is supposed to do to promote full employment, then that's not a treaty obligation that engages 51.29. Why? Because there's no real consensus about what promotes full employment. So unless you have set out the steps required to fulfill that obligation, then that's not a treaty that 51.29 will validate, a law that 51.29 will validate. Also, but though courts do recognise that in the international sphere, a legal obligation does not have to be defined with the same degree of precision necessary to establish a legally enforceable agreement under the common law. Why is that? Well, treaties are necessarily drafted in woolly terms. It's a statement of compromise and drafted in a number of languages. It has to be fit for purpose, a broad spectrum of actors, and therefore it's necessarily drafted in very generalized, broad terms. So with that in mind, we go to G Global. Now, G Global understood all of that. The seven judges understood all of these principles. And then they came to apply them in G Global. And G Global, what happened in G Global? Well, on 8th of April 2024, it was decided that they're going to remove this one provision in Section 5.1 and modify Section 5.1, which gave effect to all of Australia's double tax treaties. And all of Australia's double tax treaties have this article in them, that non-discrimination article. This non-discrimination article says that Australia must ensure to prevent foreign nationals of treaty countries, not to be discriminated against in respect of taxation. And that means that if a tax applies to a foreign national operating in Australia differently than a same person in the same circumstances who's Australian, then that's discriminatory. And the treaty bans it. Says Australia that's its obligation, is to prevent that. And how does it do it? Well, Section 5.1 Section 5.1, which gives effect to Article 24.5, basically says, forbids Australia from discriminating against, in particular, in G Global was a German-Australian double tax agreement that says German nationals with respect to taxes of every kind and description. It says, particularly Article 24 says, notwithstanding Article 2 of the double tax of the German agreement. Now, Article 2 talks about Australian tax. It says this treaty applies to Australian tax. Australian tax is income tax, which is a federal tax, and fringe benefits tax, which is a federal tax. But Article 24.5 says, notwithstanding that article, Australia is to forbid discrimination in respect to every kind and taxes of every kind and description, which necessarily meant state taxation. And that's where the problem is. And state tax had, the land tax of Queensland had introduced a foreign surcharge tax. And they were saying, hang on, you, Queensland, cannot introduce this foreign surcharge on us because we're protected by 24.5 that says you can't discriminate. So there was a Section 109 inconsistency, and it was agreed, yes? Section 109 of the Constitution invalidated the surcharge to the extent that it was inconsistent with 24.5, which was given federal effect, federal domestic law effect. And that law was introduced on the 8th of April 2024, so no longer. And the court said, well, they can introduce that. That's fine. The question is that law valid for 5129? Is it supported by 5129? That's all they wanted to do. And that was the whole purpose of it. Now, of course, there were arguments about retrospectivity. Now, that law, introduced on the 8th of April 2024, operated retrospectively, said from any assessment from 2018 on. So 6 years before that law was introduced, they said this law will have effect from 2018. So, whoa, okay, gee, it's so tough because, I mean, for 6 years you've been operating under this regime that says no, states can't discriminate against you. All of a sudden, 6 states can reopen your assessment 6 years ago, from 6 years ago, and say you owe us money under this surcharge because they've had this act since 2010. Wow, that's really tough. And you're thinking this is really unfair. But the court looked at Metwali's case, and Metwali's case, which is on retrospectivity, where a majority held that the Commonwealth Parliament could not retroactively undo or alter the invalidating effect that Section 109 previously had upon state law. So, up until 2024, Section 109 applied. But now, since 2024, Section 109, the invalidating effect of Section 109 was effectively removed, but from 2018. And why did the court agree that that was fine? So they overturned Metwali. Why did they do it? They said, because they can. Until Section 5.3 was introduced, Section 5.1 by force of Section 109 operated to render invalid the foreign surcharge imposed under the Land Tax Act because it was directly inconsistent with the federal law. So, the decision. We've got to get to the decision. Sorry, that's the next slide. I'm sure there is a decision here. There it is. Section 5.3, they said, did not impermissibly state with retroactive effect that there was no direct inconsistency. Instead, it removed with retroactive effect the basis for Section 109 to operate. They said, Metwali says you can't have retroactive effect. Well, these G Global says you can by just simply removing the conditions. Saying, well, if there's no inconsistency, if the government says there's no inconsistency, then there's no inconsistency. Again, it's giving government total, absolute, unbridled power to legislate. And this particular decision on retroactivity has been abused again. It was recently introduced. All of a sudden, the federal government now is introducing retroactive tax legislation with impunity. So that's one aspect of it. I'm not going to concentrate about that. I have problems with that, but that's okay. The other problem is the taxpayer in G Global said, well, the law, Section 5.3, which amended Section 5.1, is invalid because it's acquisition of property not on just terms. Section 5131 of the Constitution says you can't acquire property without just compensation. The court did quick shrift of that and said, well, dismiss that argument, said, well, because the law, Section 5.3, is not acquisition of property, it's genuine tax provision, it's imposing genuine taxation, and because of that, it's not acquiring property, and therefore Section 5131 does not apply. And the fact that it revives a state law, Section 5.3 revives a state law that was deemed invalid, is not also acquisition of property, it's genuine taxation. The last point there. But then Section 5.3, 5129 is what I want to concentrate on. So they said, okay, so 5131 is not going to help you, Mr. Taxpayer. Metwal is not going to help you, Mr. Taxpayer, and nor is 5129 going to help you, Mr. Taxpayer. Why? Because the effect of Section 5.3 is to limit the scope of Section 5.1 and its implementation, and thereby excluding state taxes. Okay, that's what 5.3 does, but they said it's not substantially consistent with the treaty. The limitation is not the kind of inconsistency contemplated in the Industrial Relations Organization case, because Section 5.1 continues to incorporate into domestic law the core operation of the specified agreements. So it says it's not inconsistent with the law, with the treaty, because the core operation is still going on. And Section 5.3, all Section 5.3 simply does is reduce the ambit of the implementation of Article 24. Okay, so that's a decision. Now, the problem with that decision. Okay, so just focus on the 5129. That's all I'm doing for this talk. And the thing is, before they got to that point that said it's not inconsistent with the treaty, the court acknowledged that a law that contains significant provisions which are inconsistent with the terms of the treaty is extremely unlikely to be characterized as a law with respect to external affairs. So the question then, so by reasonable inference, saying, well, Section 5.3, by just removing state taxes, is not significant. It's not a significant provision. We said that the core operation is still going on, and this is not a significant provision. You think, okay, right? And they said, but by the way, and what they did is they did a sort of a literal numerical count. Said, well, state taxes only appears in that last article, Article 24.5. Article 2 deals with Australian tax. So really, I mean, for all intents and purposes, the treaty is mostly concerned with Australian tax. But to my mind, they're saying, well, that actually, and they didn't even look at international law. And according to Justice Geoffrey Kennett, speaking extracurricularly at the Constitutional Law Conference in UNSW we had in February, he said the court looked at, characterized international law. Why didn't even mention it? It obviously must have been an unnecessary or detour distraction from the constitutional law considerations. I think, well, hang on. How can you, if the object and purpose, the validity of the domestic law must be discerned by reference to the object and purpose of what it's supposed to do, is that to implement the treaty, then surely the treaty has some play at hand. And what does the treaty mean? What is it? How can you discern the core operation of the treaty without interpreting its provisions in accordance with international law? How can you possibly know what the treaty, what is contemplated, what the treaty does, by just simply reading the text? Now, textual reading of the treaty, that's what we call a strictly literal legal interpretation. That's what happens even in domestic law no longer, because SCTAL talks about context. You need to look at context. A contextual reading of the treaty is what's necessary. And that's what comes from Article 31 of the Vienna Convention, a contextual reading. And if you read the treaty, you'll know that it gives rise to reciprocal obligations. So it's not just Australia. So what we're giving effect to is reciprocal obligations, not just the terms of this treaty. So, and how can you possibly say that Article 24.5, Section 5.3, which amends Article 24 of the, is not a significant provision? And I say there, now also, before I get to the reality, so it's removed from all reality, the judgment's removed from all reality. And I call it sclerotic decision because it's so hard and anti-internationalist, such an anti-internationalist view decision. In Queensland, now in Queensland again dealing with the Daintree Rainforest World Heritage, it says when the constitutional support for an impugned law, again it's a 5129 case, depends upon some matter of fact. Now that matter of fact is cooperation, significant provision. At what point is it factual that this is a fact, this is a matter of fact? Is this a significant provision or not? What is a cooperation? That's a factual matter, inquiry. Now, when an impugned support for an impugned law depends upon some matter of fact, a court must decide whether that fact exists. What's a cooperation? Does it exist? What do we mean by cooperation? Is it significant? Although municipal courts do not administer international law, they take cognizance of international law in finding facts. And they interpret municipal law so far as its terms admit, consistent with international law. Again, back to that customary international law rationale that I said earlier. The existence of an international duty depends upon the construction which the international community would accord to it in particular circumstances. The municipal court must ascertain the validity of the law, conscious of the difference between the inquiry and the more familiar curial function of construing and applying a municipal law. They didn't do that. They just applied as if it's municipal law. They said, look, this is a municipal matter, it's a domestic matter, and they applied an inquiry as if it's a domestic law, completely oblivious to the fact that it's a treaty that here we're talking about, it's implementation of a treaty. Now, it is well settled, and the High Court has said in 2021 in Paddy's case that you construe a treaty, the terms of a treaty, being consistent with international law. Article 31 says you've got to give recognises that treaties impose reciprocal obligations and direct courts to search for the ordinary contextual meaning of treaty terms that reflect the common intention of treaty parties. So you need to look for the common intention, not just Australian intention. Australian government's intention. Yes, we intend to override this treaty. Well, okay. Well, what are the consequences of that? Now, how can you give this law a validation? Be saying, well, it's not substantially inconsistent with the treaty. Well, okay. If it's not substantially inconsistent with the treaty, well then what is it that the treaty is trying to do? How can you say that something is not substantially inconsistent with the treaty without construing the treaty? And then construe the treaty back textually. So again, there's this problem that I see with the decision. We're going on to common intention, the last second one. Now, if you know that a major reason, a major reason countries enter into double tax treaties is to provide a more favourable taxation environment for inbound investment. It's not inconceivable that Germany would not have signed the treaty if it suspected Australia wasn't going to honour it. It's also not inconceivable that Germans would not have invested in Australia if Australia was going to dishonour its anti-discrimination, non-discrimination article. So what makes you think that that's not significant? Who's deciding what's significant? The court's deciding what's significant. Okay, now if you're doing that, then what you're doing is you're usurping executive and legislative power. Why? Because you are putting words in the mouths of the executive who negotiated this treaty. There's no evidence. There's no evidence that the court heard what is a cooperation. There's no evidence that this is not a significant provision. Yet they insisted that it was insignificant. And effectively, they think, well, you can't do that. You're overstepping your authority, your judicial powers. You're exercising non-judicial powers. So, as I say, the significance or otherwise must therefore depend on whether the innocent contracting state considers the inconsistency a material breach warranting termination. So that must come into play, but none according to the High Court. Now, just to sort of seal the deal, I thought, okay, there's a lot since the 1900s, forever. There's treaties. There's a contractual characteristic of treaties. So there's a decision in 1900, Metzger and Co. in Haiti, that basically said treaties are as binding upon nations as private contracts upon individuals. So you draw an analogy between the two. Nations negotiate treaties, terms, and it's always give and take, as you do with contracts. And so with contracts, there is an implied duty of good faith. That is a reasonable expectation that you will perform this contract in good faith. And therefore, it's the international law existing at the time the treaty was negotiated in 2016, which is the Pacta Sunt Servanda, that's been in time immemorial. So treaty partners, when they were negotiating the treaty, gave an implicit undertaking that they will enforce this, perform this treaty in good faith. It's not written. It's not expressly written in the treaty, but it's a necessary, reasonably incidental obligation to make the treaty work. Because what's the point of going into a treaty if you're not going to honour it? So going back to the Richardson case, so again, unfortunately, none of this came up in the council. Never made any of these arguments. So that's one. And then the other thing, if you draw an analogy with contract, is there's a substantial performance doctrine. Again, it's a well-recognized doctrine, the substantial performance doctrine. It says it depends on whether the broken promise is of such importance to the promisee, the innocent party, that he would not have entered into the contract unless he had been assured of a strict or a substantial performance of the promise. So that's what should determine significance, what the promisee, the innocent party, considers as significant, not what the court considers significant. They needed evidence. They didn't have any of that evidence. The term breach is an essential, but also depends whether the term breach is essential. If it's not, is it a condition? Well, even if you say Article 24(5), it's not an essential term. If it's not a condition, nevertheless, if it's not essential, then is the breach sufficiently serious that it deprives the injured party of a substantial part of the benefit to which he is entitled under the contract? That's under the substantial performance contract. So, if it's not essential, is the innocent party, the German investors, the German government? Now it's losing face with its German nationals, saying, "Sorry guys, we gave you false hope. We entered into this treaty in good faith for Germans to come, and so to encourage Germans to come and invest in Australia, but that counts for naught, according to the High Court." And so I think, well, so they're out of kilter on all, whether it's contractual, contract law, jurisprudence, or otherwise. Now, the final slide, and I know I'm way over time, is the Pacta rule that courts must have. The High Court had to, or someone should have mentioned it to them, they didn't raise it, had to take that into account and say, well, okay, in considering this law, the validity of the law, did the Australian government consult with Germany about, is there any justification for this law? Because we know that if there's anti-avoidance, if there's tax avoidance, then the countries have acknowledged that we don't have to recognise treaty obligations to get around the avoidance problem. So they introduced separate domestic law, like we have a general anti-avoidance rule, that overrides treaties. But that's for avoidance. But there is no evidence before the court whether they needed to override the treaty in respect to state taxes because there's been avoidance. There was no evidence about that. Also, with the substantial performance doctrine, then what is what we call the partial implementation principle must depend on the objective importance of the international obligation breached and the common intention of the treaty parties. You can't assess inconsistency without looking at how important this provision is objectively. rather than just doing a proportional count of how many terms, how many terms of this treaty refer to state taxes. And the last 2 points is that national courts are routinely looking to other courts on issues of international law as a source of international law. And so they're going to be persuaded by this High Court decision that says, oh, Australia's been a really good global international citizen in a lot of ways, except for when it comes to human rights. But on the tax front, we've been the model citizen, global international citizen. We have been model. We don't override treaties. There's only been one instance we overrode a treaty because of a federal court decision that was going to put a spanner in the works. But I'll forget about that. But now, this just opens the door. And what does it do also is Australia is global, enthusiastically embracing global efforts, multilateral efforts to tackle base erosion, profit shifting by multinationals, and they've just adopted Pillar 2 of the OECD to stop this hemorrhaging of the revenue base due to digitalisation of the Netflix taxes and all that. And these are multilateral treaties that make international tax law part of international law. So if Australian High Court saying no, the government can willy-nilly just up and forget about our international commitments, then what is that saying to the rest of the world? Especially when there is at the moment, global tax governance crisis where the United Nations is stepping in on behalf of the developing countries to represent their interests versus the OECD, which is the historical head of the global governance that represents the rich countries' interests. So it's like it's just chucking a spanner in the works that's going to cause all sorts of ructions and problems. Anyway, that's my talk. Have I talked too much?
I agree with this.
Thank you.